Hello everyone, welcome to today's DPP session. We are going to discuss these topics through MCQ questions. The boundary dispute between Maharashtra and Karnataka, you must have been reading about it a lot. Let's take this question. Consider the following statements. Boundaries in Indian states can only be altered through the amendment in the Constitution. Parliament of India can redraw the entire map of India without states' concurrence. No state boundary can be redrawn without the recommendation of the Indian President. So UPSC has umpteen number of times asked the power of Indian President. For example, power of Indian President when Article 356 is under imposition. In that case, the power of legislature of the state is exercised by or under the authority of Parliament. UPSC has not directly asked concerning the boundaries of a state so far, but it is the area of focus that you can infer from this question. See, UPSC has put the option determine the boundaries between the state. Although it is not the correct option, but even the incorrect options in the MCQ questions tells you what the examiner is thinking about. It tells you the area of focus of UPSC. So you need to understand the amending power of the parliament concerning the boundaries of the states. It is correct that no boundary of the state can be redrawn without the recommendation of Indian President. And then the recommendation is sent to the states to elicit their opinion. But Parliament is within its power to change the boundary as it wish after the recommendation of the President, regardless of what the state says. And that can be done by a simple legislation passed by the Parliament. It does not require any amendment to the Constitution of India as per Article 368. To change the boundary, even to change the name, you do not require any amendment. But if you have to change the language of the state, then you require amendment of the 8th schedule. And that will be considered as constitutional amendment. For instance, while changing the spelling of the state Odisha, it was a simple parliamentary law. But changing the spelling of the language Odia, it was constitutional amendment of Schedule 8. You must have read about submarine Vagir in news. Let's consider this question. Consider the following statements with reference to INS Vagir. It is the first nuclear-powered attack submarine of India. It has been indigenously designed by Mazegaon Dock Limited. Well, the nuclear-powered submarine, that is Arihant class, and INS Vagir is of Kalvari class. UPSC has asked previously in 2016 regarding INS Astradharini. It was a torpedo-launched recovery vessel, but the focus on nuclear-powered submarine you can clearly see in other options. INS Vagir is diesel-electric attack submarine. It is not nuclear-powered. And secondly, it has not been indigenously designed by Mazagon Dock Limited. Rather, it has been manufactured by Mazagon Dock Limited. It has been designed by a French company. So the statement again is incorrect. INS Vagir is the fifth of the 6 planned Kalvari class submarines. We started from INS Kalvari, then Kandheri, Karanj, Vela, and the 5th one is INS Vagir. The 6th INS Vagir is due to be commissioned in 2023. The profound ramification of one amendment, this article you saw in the Hindu yesterday, they are talking about the ramification of right to privacy. Consider the following statements with regard to right to privacy. It includes the right to be let alone, to seclude oneself from intrusion of any manner. It's a simple, straightforward statement, a true-sounding statement which is also true. It is an absolute right and cannot be violated by the state under any circumstances. See, the language of the statement is such that it sounds incorrect. As such, no right is absolute. UPSC has previously asked on right to privacy in 2021. Right to privacy is protected under which article of the Constitution? And it is Article 21. In the same year, UPSC asked another related question, which article of the Indian Constitution safeguards one's right to marry? The person of one's choice. And that would also come under Article 21. See, most of the rights can be derived from both Article 19 and Article 21 because judiciary has done liberal interpretation of the term public interest. But still, many of the important rights they are driven from Article 21 because rights under Article 21 is considered as substantive right by Indian judiciary. And there have been constitutionally imposed restrictions under Article 19, 2 and 5. That is why you will see the important rights they are derived from Article 21, right to life and personal liberty. However, Supreme Court itself has given exception to the application of right to privacy. While Aadhaar judgment, Supreme Court reiterated the triple test, also called as the three-pronged test, And if the legislature passes this test, then the law passed by the legislature, even if it is violative of right to privacy, will stand. And in general, this is the test for rights under Article 21, not specific to right to privacy. There are three tests given by the Supreme Court. The legal test or the test of mandate, meaning there must exist a law. The executive or the state action must have legislative mandate. Then there's a test of purpose. Thus, there must be a legitimate state interest for public good, or maybe the law or the regulation is being used as a tool of inclusion. And the third is the test of proportionality, meaning only minimalist and necessary information must be collected. And it was ruled by the Supreme Court that the Aadhaar bill passes this triple test. So even if you are collecting some personal information which seems to be violative of right to privacy, that's okay. So in that sense, it is not an absolute right, and in general sense, no right is absolute. Recently, you must have read about Global Biodiversity Framework. This is the first framework of its kind for conservation of biodiversity. The question for you is this: which of the following is our targets of Kunming-Montreal Global Biodiversity Framework? Protecting at least 30% of the world's land, water, coastal and marine areas? This is a correct statement. It is also called as 30 by 30 target because the target is to protect 30% of the earth by 2030. Phasing out the use of pesticide and hazardous chemicals by 2030. Well, the target is to reduce its use to 50%, not phasing it out completely. So the statement would be incorrect. Ensuring financial flows from developed countries to developing countries. This is considered to be the watershed provision in the Global Biodiversity Framework. Because for biodiversity, this kind of provision didn't exist before. Correct option would be option B. UPSC previously has asked multiple times on provisions, initiatives related to biodiversity conservation. It is a landmark initiative for global biodiversity conservation in line with Paris Agreement, which is for climate change. Just like Paris Agreement is for climate change, Global Biodiversity Framework under CBD is now for biodiversity conservation. Let's take another question on this. Consider the following statements with regard to targets in Kunming-Montreal Biodiversity Framework. Developed nation will contribute 20 billion US dollar per year by 2025 to Global Environment Facility to fund biodiversity conservation in developing countries. See, this is partly true. It is correct that this has a provision for financial flow to developing countries from developed countries, and there is a target of 20 billion USD per year by 2025, but there will be a separate instrument created for that. It will not be Global Environment Facility to which the money will be flowing. So the statement is incorrect. Large and transnational companies have to disclose their risk and impact on biodiversity. It's a benign, correct statement. UPSC has previously asked about Global Environment Facility. It's a financial mechanism for Convention on Biological Diversity and United Nations Framework Convention on Climate Change, but it does act as a financial mechanism for other conventions, other initiatives as well. The prime job of Global Environment Facility is to provide grants for various kind of conservation initiatives, for biodiversity, for climate change, for international waters, land degradation, waste management, food security, various things. It is the largest source of multilateral funding for biodiversity globally. It contributes around $1 billion. And now you see the target now has been enhanced to $20 billion per year by 2025. Global Environment Facility assets supports CBD, UNFCCC, United Nations Convention to Combat Desertification, Stockholm Convention, Minamata Convention. It also supports Montreal Protocol. But Global Biodiversity Framework under CBD, it will have a separate funding mechanism. It won't just be Global Environment Facility. You must have been reading currently in newspaper various articles on judicial independence with regard to NJAC. Which of the following is implied by judicial independence? Separation of power, judicial review, appointment to judges without executive participation, security of tenure of judges. See, judicial independence has been asked in prelims exam in various ways. For instance, in this question, in India, separation of judiciary from the executive is enjoined by separation of judiciary from the executive to allow the judiciary to work without interference. It's part of judicial independence. And this has been enumerated in Article 50, which is part of DPSP. Now, attempt this question very, very sincerely. Which of the following is implied by judicial independence? See, separation of power calls for judicial independence. So judicial independence is implied by separation of power and not the other way around. So you won't have separation of power as an answer. Judicial review is required for judicial independence so that the legislature and executive, via laws or regulations, do not start to encroach on the power of judiciary. So for judicial independence, you require judicial review. So judicial review is implied by judicial independence. Appointment of judges without executive participation. So you cannot take this as true because in other countries, for example in US, executive appoints judges, but they do claim to have judicial independence. In fact, India is the only country where judges appoint judges, or the only country where executive has no role to play, apart from sometimes blocking the appointment by not saying anything. But procedurally, they have nominal role to play. And security of tenure of judges is of course a part of judicial independence. Judges work till they are capable. They don't work under the doctrine of pleasure of precedent. They have security of tenure. So correct answer to this question should be option A.